Hello, today is Thursday, February 6, 2019. I'm Joe Schmidt from TC2, and this is Staying Connected. I'm joined today by Deb Boehling, a partner at LB3, and we're going to take a look at what the new California Consumer Privacy Act, also known as CCPA, which took effect on January 1st, we're going to look at what it means for you. Okay, Deb, thanks for joining me today.
Good to be here, Joe.
So, Deb, you recently wrote what I consider to be a great article that's posted on LB3's and TC2's websites that explains the CCPA, and it kind of provides a guide for enterprises and how to deal with their IT and telecom contracts and, I guess, this new CCPA world.
Yep, that's right. California residents were rejoicing at the California Consumer Privacy Act taking effect, while businesses were recoiling at the same. CCPA is a law that gives California residents information about and control over use of their personal information by businesses operating in California. California residents benefit from the CCPA while businesses bear the burden. The CCPA remains a work in progress. Instead of speculating on what may come from the California Attorney General and the courts in 2020 and beyond, let's talk about what changed in 2019, how those changes impact businesses that purchase IT and telecom services, and review and expand upon how your IT and telecoms contracts can reduce your risks.
All right, that sounds like a plan. Now, I know that the CCPA applies just generally to all large businesses operating in California. So what are they now required to do?
At a very high level, the businesses must do 5 things. The first is referred to as the notice of collection. A business must inform consumers at or before collecting their PI of the categories of personal information to be collected and the purposes for which it is to be used. A business may not collect other categories of PI until it has notified the consumer. A consumer need not make a request. It is entitled to receive this notice of collection. Second is referred to as the right to know. If a consumer submits a, quote, verifiable request, the business must disclose specific pieces of PI it collected, the categories of PI it collected or sold, which includes the sharing of money for valuable consideration. The business must also disclose the purposes for which such PI is used and the categories of third parties to which it sold the consumer's PI. The third is the right to delete. If a consumer submits a verifiable request, the business must delete and direct any service providers to delete the consumer's PI, unless the information is necessary for the business to perform certain functions. A business must comply with both the right to know and the right to delete obligations within 45 days of receiving the verifiable request. Fourth is do not sell. A business must notify the consumer in advance that it sells their PI so that the consumer can opt out of the sale. You've probably seen some of those opt-out notices on websites these days. You'll usually see them at the bottom for California residents only. And once a consumer opts out, the business may not sell their PI until it receives express consent from the consumer. The fifth is non-discrimination. A business may not discriminate against consumers that opt out of the sale of their PI.
So what happens if a business fails to do those things?
A business that does not do these things faces an Attorney General requested court order compelling compliance with the requirements and a civil penalty of up to $2,500 for each violation or $7,500 for each intentional violation. A court order compelling compliance could put your organization or parts of it temporarily out of business until it complies, and implementing the underpinnings for the compliance takes time.
So, okay, Deb, do consumers have any direct rights if a company messes up?
Consumers don't have direct rights. They cannot enforce the above requirements. They can, however, seek damages if their non-encrypted and non-redacted PI is accessed and taken without authorization because the business didn't have reasonable and appropriate security processes in place. The consumer enforcement, or what we refer to as the private right of action, does not require the consumer prove actual damages, and proving actual damages is very hard these days. The consumer gets damages of at least $100 per consumer per incident.
Now, your article, it lays out a lot of really useful information about, I guess, the evolution of CCPA and some recent amendments. Unfortunately, we don't have time to cover all of the detail on today's podcast, but I do want to get into how CCPA impacts an enterprise's IT and telecom contract.
Sounds good.
So what's the issue with these contracts?
In providing IT or telecom services to you, your suppliers receive personal information such as telephone numbers, IP addresses, possibly names of the persons you invite to a conference call or to a web conference. These persons may be your employees, but they can also be your customers or your advisors or your regulators. Your organization is responsible to protect these folks' information and is responsible for your supplier's use of this PI consistent with your CCPA obligations. The notice of collection, the right to know, the right to delete, the do not sell instruction, and the non-discrimination requirement. The CCPA recognizes your dependence on suppliers and provides several ways to avoid responsibility for your supplier violating the CCPA restrictions on use of the PI it receives from you. These restrictions include the do not sell obligation and the obligation not to use PI beyond the purposes in your notification of collection. The CCPA also allows you to avoid sales-related obligations such as do not sell if your service provider follows certain rules.
Hey, why don't you highlight a few requirements companies should have in their IT and telecom contracts?
To avail your organization of the benefits we've just kind of gone through and the benefits that the CCPA provides, your supplier contract must prohibit the sale of personal information that you share with them. It has to prohibit the retention, use, or disclosure of that PI, except for certain limited reasons that are permitted under the CCPA. And the contract must include a certification that your supplier has read and understands these restrictions. It must also prohibit any further collection, sale, or use of the consumer's personal information, except as necessary for the supplier to perform services on your behalf under the contract with the supplier, or for activities in your service provider's notice of collection. And your IT and telecoms contracts should make sure that your service provider is responsible for any harm your organization suffers if the provider's actions or failures cause you to violate the CCPA. It should also require your service provider to generally assist you with your compliance with the CCPA. Before finishing, though, your contract, you need to review your own limitation of liability or that in the proposed contract in the disclaimer of damages. Because if your organization is able to collect the harm the service provider caused, they've agreed to that provision, then you need to make sure that the limitation of liability in the disclaimer of certain types of damages doesn't prevent your organization from collecting all it's owed. Joe, those are just a few of the requirements. My article provides more detail.
Yeah, it sure does. So what should an enterprise expect from their supplier?
In our experience, some suppliers readily agree to most of the above contract requirements, the exception being the supplier's obligation to protect your organization against all harm suffered if the provider's acts or failures cause you to violate the CCPA. Other suppliers, however, resist strongly without the involvement of counsel that understands the CCPA complexities. Of those suppliers that resist, some point to the temporary business-to-business or B2B exemption that was passed in 2019. They point to the general compliance with law clause and the confidentiality clauses that may be in the contract. Don't fall for it. The business-to-business exemption only covers the information shared by your employees with your service provider as part of their work. It doesn't cover any other information that they may share with the service provider, just in a friendly manner. They might be friends. And you remain responsible for the service provider's protection of that information. The other problem with the B2B exemption is it expires on January 1st, 2021. If you don't negotiate now, you'll have to do so later this year to make sure you get appropriate protections from your supplier. The general compliance with law provision, that may say that your supplier is going to comply with its obligations under the CCPA, but those obligations are not the same as the obligations you have to your customers and your employees under the CCPA. And it does not mean that the supplier is going to help you to meet your obligations. The confidentiality clause is also unlikely to reflect the very detailed prohibitions on retention and use of personal information that is required by the CCPA.
Okay, thanks, Deb. Now, this is some really important information, and I encourage those interested to read the full paper. Now, If you would like to discuss CCPA or other ICT needs with Deb, me, or any of our LB3 and TC2 colleagues, you can give us a call or you can drop us an email. Now, if you like these podcasts, you can subscribe to them on a number of platforms like Apple and Spotify. And we also encourage you to check out Deb's paper on our websites and all the other content that we have on our new websites, and to follow us on LinkedIn.